So thank you. You've been such a terrific audience and you keep on listening, I hope, for the last bit of today. I'm really honored to be here and to be able to tell you briefly in just 20 minutes the results of 5 extensive DPIA investigations we did. Let me see how this works. Yep. Yeah. Sorry. So, who am I? I used to work for the Dutch Data Protection Authority for the last 12 years. Since a year and a half, I work for a privacy company, which is a specialized privacy consultancy group with about 30 professionals. I'm also an external DPO for 5 companies besides doing the DPIAs. Sorry, forget. So we did the first DPIA for the Dutch Ministry of Justice. We published it in November 2018. It's still available in English with the appendices. And what we found out was that a year before, I did an investigation for the Dutch DPA about telemetry data from Windows 10. So it's, if you remember the movie E.T., it's Microsoft phoning back home what you're doing on your device, right? Somebody mentioned Tamagotchi, so I should be able to mention E.T. And now we inspected the telemetry data stream, the technical data sent back from your Office installation back to Redmond headquarters in the USA. And we found out that it was on even a much larger scale. Microsoft systematically collected data about your use of the software. So it had quite a big impact when we published this report. And then in June of this year, we did sort of a repeat investigations, DPIAs for the same Ministry of Justice in the Netherlands. And then you have to sort of understand the scope. So you have, in an enterprise environment, we didn't look at the customer, the regular user versions you may have at home. We looked at the enterprise version. Very costly software, I can tell you. It consists of a number of different ways of using the software. Pro Plus, it's a term you'll hear more often during my talk, is the installed version, like the old Office we all know. But Microsoft is also has, as a company, has the slogan mobile first. And so they also have developed 2 other versions of the software online, which you access through your browser. You don't install it on your device anymore. And the apps. For example, the Outlook app on your smartphone. And then we looked for the DPIA. We had to determine the scope. Because Office and the whole license for the Office enterprise version includes so many different software elements like Intune, mobile device management. We can't do everything. So we decided to just focus on the 5 most commonly used elements: Word, Excel, PowerPoint, Teams, and Outlook. These 5 core services connect to cloud services, SharePoint, OneDrive, but also your authentication through Azure. And then to your right, there's another cloud drawing, and it used to be called Connected Services, and now it's called Connected Experiences. And this is sort of hard to grasp, but previously, when you used a spelling checker in Word, it would be a local spelling checker. It would learn from your behavior and an inbuilt dictionary. Now, if you currently use your spelling checker in Word, it looks up data in Microsoft's cloud. That means that data are leaving your device. And there's a number of these connected experiences that mean that your data leave your device in your environment. So what did we do in the DPIAs? We, of course, you're all familiar, we checked the fine print. Somebody asked before, who's actually checking the standard contractual clauses? I am. But it's not limited to just the legal assessment. What is critical about our understanding of the actual data processing is to look at the actual data processing. So we intercept the data traffic and we analyze what is leaving our device and why. And so in June, we published the 4 new GDPR reports on Windows 10 on the different Office versions, and they're just publicly available. They're in English. Feel free to read them, reuse them. I must warn you, they're about 100 pages each, but there is an English summary, a 3-page summary. So, of course, a good GDPR doesn't just describe facts and risks, but also provides mitigating measures. And a large part of our GDPR reports is what you can do as an enterprise user of Office to mitigate the risks in your particular organization. So the contract structure is not the most transparent contract structure in the world. We thought we understood it when we looked at the business and services agreement and all the underlying services terms and SLAs, but then we found out while we were digging through the legal contract terms that there was a whole separate category of data that did not fall under the official contract structure. That was for the connected services. The Microsoft Services Agreement and the Microsoft Privacy Statement apply. This is really confusing. You buy an enterprise license for your government employees, because that is what the Dutch Ministry of Justice does. They procure the software for 300,000 Dutch government officials. And then the individual organizations actually pay for the software and install it themselves, but it's a general national procurement office. And then you would expect that all use of that license would fall under that same contract structure, but that's not the case. And that's one key takeaway from all the GDPRs I'm describing. You have to be so alert when a company considers itself to be a data processor legally, and when suddenly other privacy terms kick in and the company considers itself and qualifies itself as a data controller. So the technical analysis of the Office is as follows. It's like the magician. Microsoft has this really good story about trust your data with us in the cloud. That's the green lockbox. It's secure. It's safe. Nobody can access. You can use customer logbox. You can use disk encryption, you know. But nobody's watching the left hand, because the magician is actually collecting all these diagnostic data about your access to the lovely green box, right? So this is an important distinction in the GDPRs, and you can only find out if you actually look at the data stream, because otherwise you just keep on reading the nice stories about the green lockbox in the contracts. How do we determine the risks? This is different from the way security officers determine risks. This is important to know. We use a matrix developed by the ICO, the UK DPA. They have had a very long experience with this kind of data protection impact assessments. If you use a regular security risk assessment, you will see a diagonal of medium or high risks. But in the data protection world, there's a very large quadrant of relatively low risk. On the other hand, if a user cannot get access to his or her personal data, that's a major violation of data protection rights. Maybe from a reputation risk assessment point of view, you might think, so where's the harm done? I'm not doing anything wrong. It's just not providing timely access to the data I have, but I'm not doing anything, not causing any harm or damage to that user. In data protection risk assessment matrices, you end up in the right-hand top corner, high risk, because you violate a fundamental principle. So this explains why there's sometimes a bit of misunderstanding between the security and the privacy people. I hope I helped bridge that, and we can all have a party now. So prior to the negotiations, and this is what drew a lot of media attention, we said in our assessment there were 8 high data protection risks for enterprises using Microsoft Office. I'm not going to talk through all of the 8 risks, but I'm going to highlight a few. For example, unlawful processing of very sensitive categories of data. I just explained that when you use the spelling checker, your data actually leave the device, right? And so the sentence before and the sentence after the word you're looking up the spelling for are sent to Microsoft. Of course, logically, not with any evil intentions, but for a government instance like the Secret Services, they do spelling checking. And of course, if you've ever done spelling checking in Office, you'll see the entire document is read. So all sentences are basically sent to the USA. You would want to know in advance. And you would want to be able to say, no. The same applied to the translator. So suddenly there was a huge upheaval also in our parliament. Like, why didn't we know about this? The incorrect qualification, I heard the discussion this morning. It was extremely high-level discussion about joint controllers, so I'm sorry to bore you now, but the way I explain as a DPO and to large groups the difference between a processor and a controller is that the lady that serves you coffee is not allowed to serve you tea, even if she says, but I think it's much better for you. And I make more money when I serve tea than when I serve you coffee. And when the delectable Nigella Lawson is in your kitchen, your data are being cooked, right? And she's the data controller. So that's how I try to explain. And that's the set of glasses I wear when I read legal terms. So what is this company actually doing? Are they serving me the coffee I asked for? Or are they actually selling me a lot more I didn't ask for? And that is closely connected to the lack of purpose limitation. So Microsoft only has one purpose in its legal terms, to provide the service. And if you read very carefully, all purposes we deem compatible. Now, so we interviewed a delegation from Microsoft and asked them, so what does it mean? What do you actually do with the data? And then they came up asking them hard questions with actually 8 purposes that fell under this one word, providing the service. The orange marked purposes are the waitress serving me tea. So this is what got me very suspicious. Purposes as a data controller could be found in the general privacy statement. Again, the orange marked purposes put my hairs on end, right? Research, what does it mean if you use my data from my spelling check for research? Or product improvement, does it mean you're actually detecting the apps I'm using from competitors for your business intelligence to buy that competitor? If you don't describe it limitatively, I can't exclude such further processing, which would be illegitimate. So the last one is the transfer. I also heard a great discussion today. So Max Schrems 2, the Advocate General, will issue his opinion on 12 December. We're all waiting what the outcome will be, right? But there's a second case that will also be dealt with immediately after 12 December from the French NGO La Quadrature du Net about Privacy Shield. So even if standard contractual clauses would survive in the advice from the Advocate General, there will be a second case about Privacy Shield as well. So in February, Microsoft announced global changes. There were questions raised in Parliament in the Netherlands, and then Satya Nadella promised to update Office Pro Plus globally. This is one major advantage of dealing with hyperscale providers. They will tell you for a very long time, no, we can't change anything, we're way too big. We can't make any individual modifications for you, and besides, you're the Netherlands. What are you talking about? Huh? 300,000 people, come on. If we don't want to, we don't service Europe anymore. How about that? But once they start to move, and the big advantage was that the GDPR report was written in English and was made public and drew a lot of global attention. In the magazine Politico, it's my personal insight that if you want to change anything, you have to make sure you're interviewed by Politico, because then the California will read it. So anyway, once they start to make changes, the changes are global as well. So what happened? Microsoft made global improvements, and it also helped that the EDPS also announced an investigation of the contract from the European Commission with Microsoft. So we went to Seattle and we negotiated. And what happened is that Microsoft made a number of huge technical improvements for all enterprise customers worldwide, because they can't really distinguish, because they're operating on such a large hyperscale. But they also made a number of specific legal improvements for the Dutch government. The slides will be sent to you after the meeting, so don't worry. You can read all about it later on. The most critical thing from our point of view is purpose limitation, only 3 purposes we can really understand, and an effective right to audit. And the Dutch Ministry of Justice promised to our parliament that they will conduct an annual audit on compliance with these principles and publish the findings. So more goodies to come. So there's a few remaining risks you can read all about in the GDPR report. And the problem is that Microsoft, for the mobile apps, once again, like with Windows 10, they think they're a data controller. And if you've been paying attention this morning, my conclusion that factually they are joint controllers with you should not be a surprise anymore. And then Microsoft is not the only one. I'm personally living in a candy store, because I'm also working on new GDPRs on Amazon, Oracle, and Google G Suite. And there's more candies in the store for me to explore. And the last slide is about the Cloud Council. So, of course, the Dutch government remains a tiny customer in the eyes of Silicon Valley. So we tried very hard to unite forces of all the public sector procurement officers. And fortunately, 2 of your Swedish government officials were present, Daniel and Anders. They raise your hand. Oh, Anders were present. They can tell you what went on. So it was a meeting in The Hague, organized by the Ministry of Justice together with the EDPS. And the end purpose is to draw up sort of our standard terms and conditions, instead of forcing these terms and conditions through our throats with take it or leave it. If we unite in Europe as public procurement organizations, we can tell these organizations, right, now you accept our terms, please, and be GDPR compliant. So my last sentence is, privacy company is really cool, and if you want to join us as a partner in Scandinavia, contact me. Thanks.
Thank you. Thank you, Sjoera. I think that we have time for 1 or 2 questions. Might there be 1 or 2 questions somewhere in this crowd? There.
That's a good idea.
So, my name is Hans, consultant from Kvadrat. You talked about the Pro and Enterprise versions. Have you any idea of what goes on in consumer versions?
No, sorry. I didn't even examine Pro, which is more the SME market, small and medium-sized enterprise. I only looked at the enterprise environment, because that was my principal. He only buys the enterprise version. I think it's up to the data protection authorities to use the findings of these GDPR reports, which are really extensive, to draw their own conclusions for consumers.
And you don't have any suspicion, even?
And we have a second question right in the middle of the room.
The orange.
Yes, it's that.
Yeah.
Yeah? Okay, now. My name is Bahar Malavan. I'm from Andra AP-fonden. I was just wondering, regarding the enterprise version, do you believe that do you believe that all enterprises are able to actually go into a negotiation with Microsoft, or because you were speaking about Netherlands, but do you think that Microsoft really would be able or open to go into negotiations with any sort of enterprise, even smaller ones?
No, I don't think they're willing to negotiate with any small enterprise. So the advice I gave in the Netherlands, because a lot of enterprises contact us as well, is try to unite through like an association or a professional organization. Try to create leverage. I mean, if the Netherlands as a public sector procurement partner is hardly serious because we're too small, then one small company is not worthwhile for Microsoft. But the good news is, for example, and I think you have a similar system in Sweden, is the municipalities in the Netherlands are completely independent from central government, so decentralization at best, right? So the central government new contract conditions did not apply to the municipalities. And for example, they do not apply to universities because they're all independent from the central government. But now the association of all Dutch municipalities has been negotiating with Microsoft, and they've allegedly, I don't know, obtained similar improvements. And the Central European Procurement Organization, which buys for all the universities in Europe, is becoming awake and getting interested in negotiating similar improvements. So that's the way to go. If enough organizations in Europe unite their powers, it will become more attractive for a hyperscale provider to make one change globally instead of having to negotiate individual improvements with different organizations.
Thanks.
Thank you so much, Sjoera.
All right.
This was very interesting.